Good morning, everybody. How are we? It is 11 a.m. where I'm at. So I thought I would come in and say hello. We'll play a few videos. Hello, Beamer Green Eyes. Good morning to you as well. So what's going on? So I've been putting some clips together. I found some new stuff. I got some old stuff. I'm combining some new and old stuff together. uh, Still playing with the sentencing thing. I don't know what I'm gonna do with that yet. I'm working on that for you guys, so I'll let you as soon as possible. In the meantime, what I thought we would do today is go back to some old clips that this is stuff that I posted a long time ago, and before my channel got changed over. Thank you, Steve, for hitting the like button. I appreciate that, and welcome in. Hello, Miss Barbara. All right, let's get to some videos.
I provided you yesterday as a courtesy with a copy of my oaths of office. My name is on that as well.
They were not certified.
You are attempting to disrupt with asking questions like this.
I am not.
I realize it may very well be related to your claim to be a sovereign citizen and disputing the
Claim to be sovereign, that's correct.
jurisdiction of this court, but these are not questions. You believe you're sovereign, the record is corrected. So, Mr. Brooks, we're getting really close for you crossing the line,
Really close to crossing the
being
line,
removed
Your
from
Honor.
the courtroom for continued interruptions.
I do not
want you
consent to
here.
that, Your Honor.
Mr. Brooks, you haven't let me get in one sentence this morning.
I
And
haven't.
it is only, it's 8:57. I want you to be here. Certainly my preference is for you to be here to participate fully, but you do not have the right to disrupt the proper administration. I demand dignity, order, and decorum. You have been provided with the copy of SCR Chapter 62 that lists the responsibilities that myself, the attorneys in this courtroom, the litigants, it even applies, as you can see if you read it, applies to witnesses, jurors, those in attendance. Everyone here has been respectful other than you throughout these proceedings.
I object to that respectfully. I have not been disruptive, and I do not see any paperwork that you just described to be in front
Mr.
of
Brooks,
me.
I'm going to continue with a finding right now that you have flagrant.
So this was early in the trial, and he didn't say that. What is it that he say? I accept this. Oh shoot, I forgot his. Can you believe it? I forgot what he says. Come on, somebody in the chat. What does he say when he receives something? Return for value, accept for value, and return for value. This paperwork. Grounds.
Disregarded elementary standards of proper conduct. That conduct will not be tolerated. You stating things even in a mild manner tone of voice doesn't change the fact that we've had a dozen or more interruptions by you and by you alone. When you don't like the answer I give, even if that's a non-response, you continue to ask the same question over and over. You repeat yourself. You show absolutely no respect for the court, for these proceedings. You have demonstrated in the short, not even 30 minutes that we've been on the record, that you will continue to disrupt. I am going to have the jurors brought in. Again, it is my sincere hope that you follow these simple and basic rules, but the next interruption, you will be removed to the next courtroom.
I do not consent to any paperwork that is not based factually in law.
Who thinks that he really knows what he meant when he said that? Who thinks he knows what he know? Who thinks he knows what he's talking about? Maybe I should put a poll up in the thing and ask if you would hire Darrell Brooks as your attorney.
I don't give my consent,
We have the jurors here?
and I will not agree to anything.
Not yet, okay.
So again, with that title, I object respectfully. With that title name that is on your card, since you will not answer the question that I've merely asked of Your Honor numerous times at this point, can that title name please direct the prosecutor to answer whether there are any more charges? Can the title name please direct the prosecutor to answer whether there are assessment for the charges
Mr. Brooks.
in her possession?
No one's going to be answering these questions, okay? I'm not requiring an estate to do that. I'm advising you to stop asking those questions.
request
It will
the-
be considered he's interrupted.
I
Take him to the
request
next
the title
courtroom.
name.
I'll make more findings when he is in the courtroom next door, and I can do that without an interruption.
I do not consent or agree to an estoppel, and I will move the court again.
All right, Mr. Brooks? All right, you can mute him. All right, Mr. Brooks, you have been muted so that I can make some appropriate findings here this morning.
Really quickly, I wanted to say one thing. You guys, I think he thinks when she says you've been muted that he thinks he can't hear or talk. Swear to you, I think that's what he thinks. Because I was watching some older stuff, and the way he was acting about it, yeah. Or okay, or maybe he's got me bamboozled, and it's just more of his junk to try to get past, what really needs to get done.
I understand that you object. Your objection is noted. Your lack of consent is noted. As I indicated earlier, I lost track after about a dozen or so interruptions by Mr. Brooks. He continues to ask questions that I told him I would not answer. And even though I made a decision not to answer questions, he keeps asking those. From my perspective, they are questions that any sovereign or sovereign citizen tends to ask regarding my name, my oath, jurisdiction, things of that nature. This court, of course, has authority from the Constitution of the state of Wisconsin, the statutes. I've been duly elected twice now by the citizens of Waukesha County to preside over criminal and other cases in the courts of Waukesha County. I fully am aware that Mr. Brooks, as a sovereign, disputes the validity of that, but from my perspective, they are not issues that need to be debated. He raises these issues really just by simple statements. He has never filed an appropriate motion. Motions are governed by state law. Written.
I know, Olivia, but he acted like he thought it meant that he could not hear as well, is what I'm saying. And it was like he was trying to use the fact that he was on mute, that he couldn't hear what was going on in the courtroom. Just craziness.
Motions require that the specific relief be requested, that the motion be based on law and fact. I've never gotten anything even close to that from Mr. Brooks. Even if I were to accept an oral motion, which can be proper at times, he has failed to follow the simplest of procedural requirements. He continues to be in the other courtroom. You can see on the monitor, he's standing, he's facing the other direction, he's yelling what, I can't hear him, but it appears that he is yelling. I muted him because of his interruptions of the court, and I understand he objects. His objection is, again, once is noted. And because of the disruptions, and based upon the authority in Illinois versus Allen, I also referenced yesterday a persuasive case. It's not at my fingertips. I'll get that for the record. It's the Pennsylvania case that I found to be of persuasive value, where a similar procedure was done frankly, what we are providing here in Waukesha County through the use of the technology we have in the courtroom is far superior to what was done in that Pennsylvania case. I have the ability to mute, to unmute. I can see him. He can see the 4 cameras in this courtroom right now. That would be me. It would be the table where I.
You know what's funny about this? This was before, I think there was only like 1 or 2 cameras that were following, or news stations that were following this really then, and we didn't get the full, as you can tell from this video, this was before they even got all the real cameras set up in there with the good audio. The audio is really good though. But, it was just funny is that as the trial progressed within just days, all of a sudden, all of the media outlets were in there and everybody wanted to live stream it and update the trial all over the nation.
Would like him to be seated, that is empty, the prosecution table, and then the witness stand. I am cognizant that the one limitation is the cameras do not pick up the jurors when they sit. There may be, depending on the angle on the witness stand, a few jurors that would get captured, but of course he cannot see those. He's able to hear them, of course.
I did want to address a topic that's maybe not been.
Okay, I want to say something really quick before y'all watch this. This was early on in my video editing days, so some of these are speeded up, and I do apologize.
Raised in the courtroom, but has been raised in the public, and it seems to kind of go hand in hand with the events of this morning, and that is the mental competency of Mr. Darrell Brooks to proceed to trial. The court is well aware that the district attorney has an obligation and a duty to raise any concerns as to the competency of any defendant to proceed to trial. Any counsel representing Mr. Brooks would have that same obligation, and the court itself, if it had a concern as to the competency of any defendant to proceed, can request an evaluation that's pursuant to 971.14 of the Wisconsin statutes. At no time has anyone involved in this case had a competency concern. And I say that based on the fact that Mr. Brooks has made multiple court appearances, most of them before Your Honor, but at least initially he appeared before two court commissioners. He's had counsel representing him up until last week on this case, and you've made a record with Attorney Perry previously as to Mr. Brooks' ability to understand what's going on and his ability to participate in his own defense. You made a thorough record last week when you went through his waiver of right to an attorney and his absolute desire that he expressed multiple times to represent himself. I would also add to the record, and I will provide this at a later time, what I referenced yesterday, the jail calls that are all recorded. I will make a record at a later time. I'll prepare an exhibit and have it made as a court exhibit as to some of the discussions he's had with other individuals. He makes multiple phone calls every day, and they are all listened to. He is coherent, he is intelligent, he knows the issues in the courtroom, he discusses what happened in court that day with these individuals he's speaking to. I am thoroughly convinced, Your Honor, that Mr. Brooks is 100% competent to proceed to trial, that his mental capacity is not reduced in any fashion. Anybody that thinks otherwise has no involvement with this case. I would reference the court to today's filing, which Mr. Brooks provided. It is extremely well written. His handwriting is immaculate. It's perfect. The punctuation, the grammar is 100% accurate. He drafted this himself in his jail cell last night, I presume. Maybe it was this morning. He has continued with the same objections that he has been making repeatedly in this case, so he clearly understands the issues. He understands the defense that he wants to pursue. He undertook the effort to have this form notarized by a jail employee so that it is a signed and sworn affidavit. Absolutely no concerns on the part of the state of Wisconsin that Mr. Brooks has any deficiency in his competency. We are 100% convinced that these actions of Mr. Brooks are deliberate and intentional, and they have escalated, and the court has seen this since August 25th or so, as the motions were decided by the court, most of them to his detriment. His behavior became more and more difficult in the courtroom. It started out less aggressive with him sleeping and asking to be able to leave the courtroom.
Oh, you see this, him pointing at his finger? This is where he got injured. His little baby pinky finger. That little baby pinky finger, he got a paper cut. So we gotta stop the court. He needs a sick day.
Then we had toothache. Then we had a situation where he didn't want to come to court, was refusing to come to court. The record will be clear, Your Honor, that each time, and the Sheriff's Department has done an absolutely fantastic job dealing with Mr. Brooks fairly, professionally, respectfully at all times. We concur 100% with the record you just made as to what happened after the recess at about 8:42 this morning as to Mr. Brooks' conduct. These are deliberate actions on his part as we get closer and closer and closer to actually presenting this case to a jury, that he is attempting to derail these proceedings and avoid the inevitable. And I want to make that record. I tell this court, as an officer of the court, we have zero concerns as to the mental competency of Darrell Brooks to proceed, and we have had many, many dealings with him on the record and off the record that I base that on. I also wanted to add one other comment as to the court's record as to the need to proceed with this trial. We concur 100%. We would also note it's not just a matter of resources. It's the need to proceed to justice. It's the need to get justice for the crime victims who have patiently attended every one of these hearings. They have a constitutional right to trial. They have a constitutional right to a speedy disposition of this case. And that doesn't mean hasty. That doesn't mean reckless. It means efficient administration of justice. And this court.
Kimberly says she would love to know what he's saying when acting a fool in that other courtroom, and I 100% am with you on that, Kimberly. Oh, you know what? Those bailiffs, they could write a book. Girl, you know they could. I would love to hear it. If they all got together, could they do that? I would pay for it. I would pay whatever it costs. We would have open readings here on the Character Productions channel of snippets from different bailiffs. That would be crazy. Maybe they're all close to retirement and they can do it after they retire.
Court has provided that to the crime victims, and we think that's another reason that Mr. Brooks' antics, which is all they are, clearly speak for themselves. This is not his inability to understand what's going on by any stretch.
At 8:42 a.m., this court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. This, of course, comes on the recent history with Mr. Brooks. On every day that we have been in court since Monday, he has shown a complete and utter disrespect for the simple rules of civility. He has been removed from the courtroom multiple times. This morning alone, he started interrupting this court within a minute of the court calling the case. I should also make a record at the moment he is muted because of the way that he was removed from the courtroom and his conduct since. I have been given just a bit of information about it. I will advise everyone that I have required that the Sheriff's Department file a written report with the court regarding Mr. Brooks's conduct. I'm told that he would not sit down while in this courtroom in order to have the shackles removed so that he could be taken to the other courtroom, that he was resisting, that at one point he took off a shoe and it appeared to the deputies that he was going to throw the shoe. He took his shirt off as well. I'm also told that he is threatening to throw and break items. Through his conduct, he has forfeited his right to be present. I'd also make a finding that Mr. Brooks today, of course, showed up in court from the jail in his jail attire. He does that by his choice. I gave him the opportunity to go back to the jail to put on his suit and tie or other street clothes. He refused to answer that question. It is important for all involved that this trial continue. I will advise Mr. Brooks, as I have advised him repeatedly.
Hey, is the volume too high, guys? It sounds a little high to me. He needs a SpongeBob. He needs a SpongeBob Band-Aid for his paper cut. You're right, Kimberly. No one's afraid of him, and he can't stand it. He wants to be the man. But you know what? He should be used to that in life, though. So you think they recorded it when he went off on these rants and tangents over in the other courtroom, and he was just going off? There was somebody over there recording what he was saying. Matt, if I could do that, I don't know if I'm creative enough, but that would be hilarious.
If at any point in time he wants to come back and he is willing to promise that he will abide by the rules of courtesy and decorum and be civil, and show respect for the court proceedings for all individuals in this courtroom, including Mr. Brooks himself, then he may come back in. I will further advise Mr. Brooks that his continued behavior, whether it be appearing in court in jail attire, whether it be causing disruptions in front of the jury, that he does all of those things at his peril. But I will, of course, take appropriate steps to limit what the jury can hear, if appropriate. That the record is very clear. I will note a continuing objection to the issues he raises regarding his name and other things. There are filings that substantiate that. It will be my position it's not needed for him to do that every single day because I've noted a continuing objection. This behavior is frankly more in line with someone who's defiant, deliberate, and in line with the conclusions related to whether he suffers from mental disease or defect that would qualify for a special plea. I've not gone into much detail, and I won't. Those documents are part of the record, but it's very clear to this court that everything that he has done, as outlined by the state and as made evident on the record of these proceedings, that it is the sole intent of Mr. Brooks to make a mockery of this process. And I've stated, and I'll state it again, I'm not going to tolerate it, but there is, I believe this trial needs to continue, should continue, not only for Mr. Brooks as the accused, who also has the right to a speedy disposition. He hasn't exercised it. The victims have a right to a speedy disposition. And it's important for the justice system to go forward with this proceeding. We are at the stage where we are at with Mr. Brooks muted in another courtroom because of his defiant actions. No one else. And I appreciate everyone's patience as the court goes through these things. Frankly, it gives Mr. Brooks time after time after time to conform his conduct to the clear expectations, but he just simply flat out refuses to do so. Mr. Brooks, I'm going to unmute and ask you if you have any objection to the jury instructions that were provided to you yesterday. I'm specifically looking for a yes or no answer, and I'll address further if need be based upon that yes or no. The microphone is unmuted. Actually, we'll need to turn him up. It's not very loud on our end. Mr. Brooks, did you say one more time? Yeah, but you know what? Your volume's a little low, so we're going to have them adjusted over there and in here. So give us a second. Mr. Brooks? Try again.
Am I on the record?
You are on the record. Ooh, that's loud now. We'll turn ours down. Mr. Brooks, yes or no question, do you have any objection to the preliminary jury instructions that were provided to you yesterday? Go ahead, answer please. All right, your objection is noted for the record, and I'm just putting the mute back on. He provided that objection without any legal basis. I muted him just so I could ask this question. I'll be right with you, Captain. Mr. Brooks, do you have a legal basis to object to those preliminary jury instructions? I'm unmuting you. Hold on, the volume is not being appropriate at the moment. Try it again, sir. I apologize for the technical issue. All right, the technical, we're going to have to figure that out. It's not appropriately working. I do appreciate that he was able to hear me because he leaned in to answer, so I just want to make that record. I'm going to go take a recess. I'll just mute while we're doing that, just so I can figure out what the audio issue is, and then we'll go from there. To have our technical issue resolved when I needed to take the break for the audio issue, I also was advised by the captain that Mr. Brooks was requesting medical attention and reporting a small cut to a finger as a result of when he was removed from this courtroom and taken to the other courtroom. I was further advised that there are no signs of blood and that when asked, he refused to show his hands. At this time, I'm not going to pause the proceedings further for him to be seen by jail medical, but at an appropriate break, that will be done. And I also want to make a record that Mr. Brooks has put his shirt back on. He continues to sit with his back to the camera. Mr. Brooks, I want you to be advised that I believe it's important that you face the camera so that you are facing the court. You can see and hear. It's my understanding you were not willing to cooperate with being shackled, and for the moment, you are not. But at this point, given your conduct from before, I'm going to require after we take the next break, that the Sheriff's Department put you in the chair face forward and with shackles on your ankle as you are in custody, and that is appropriate. Now, I want to turn back to the issue with the jury instructions, Mr. Brooks. You indicated you had an objection. My next question to you is, what is the legal basis for the objection? I'm going to unmute so you can answer. Go ahead, sir. You need to turn around so I can hear you. Part of the issue is he's also not facing the microphone, and so I need to hear him, and he needs to turn around.
Darrell
Mr. Brooks,
daycare
I'll ask you
moment.
once again, what is the legal basis for your objection to the jury instructions?
He wants his passy.
I'll ask a third and final time, sir, what is the legal basis for your objection to the jury instructions?
I wasn't loud, so I can't even hear what she's saying all the way, man. It's too low.
You want your headset?
Mr. Brooks, I can hear the deputies over there. I know they can hear me. That's been confirmed.
But the one thing that drove me nuts is how the bailiffs had to kind of cater to him. The deputies had to cater to him. Do you want this? Do you want that? And he kind of used that whole scenario to like boss people around. And like when he was throwing his papers on the ground and they'd have to pick them back up and hand them to him. I mean, yes, utterly disrespectful. We know that about him, but it just drove me crazy because that's not their job, I don't think. They deserve better than that.
There is the headset available to use should you wish to use it. If you can't hear, I would ask that you put them on.
You just put it down.
I'm able to hear. He said to the deputy, put them down. I don't want them. All right, I'm going to mute once again so I continue with my record. He did not answer the question, what is the legal basis for the objection? I asked that question 3 times based upon that non-response. His objection is noted for the record, and I will approve the preliminary jury instructions that are on file with the court. Obviously, they'll be uploaded once I read them, but all parties have been given copies of those.
I kind of like it in fast mode, though, to be honest.
Before I turn to the motion for reconsideration, you raised this earlier, at least the topic of it. Mr. Brooks presented a filing to the court this morning. I asked the bailiffs before the case was called at 8:30 if Mr. Brooks had any paperwork and to ask him if he had any filings. He then provided this piece of paper and it was photocopied. Actually, it was date stamped, then photocopied for the parties. It may have already been scanned in, I'm not sure, but it certainly will be. I've had an opportunity to review this document. Based upon my review, I don't believe any response is even required. It's his affidavit. He's providing certain disclosures, but there's nothing about that that requests any relief from the court. Certainly no legal statutes or constitutional provisions are referenced. To me, it just looks like an objection that he's filing, and that will be, of course, noted for the record. Attorney Opper, anything you would want to add to the record on this, any position you are taking?
No, I also viewed this as, because he labeled it objection by affidavit, I think my interpretation is he was trying to make a record for appeal that he objects to the court's previous ruling. I don't think there's anything the court needs to do with this document at this time.
All right, thank you. Then we'll move on to the motion for reconsideration. And again, I'm keeping Mr. Brooks muted so that I can get through this process orderly, efficiently. When necessary, I will unmute him if the court has questions. All right, Attorney Opper, I have read through the motion. Is there anything you want to add to what you have put in your filing?
Only one other observation, Your Honor, that since
I think, Granny, wasn't his appeal like, didn't they throw that out? Do we have confirmation on that? Has anybody seen confirmation? Because I have not seen anything formal.
I filed that the events of the last couple of days, I think further support my request, not that the defendant's behavior in the courtroom has anything to do with the broadcasting of victims and witnesses, but I think the stress that is going to be placed upon them potentially by Mr. Brooks' behavior will be additional challenge to them as they testify, and so not having their faces displayed, I think, would help ease some of that tension for those individuals.
I 100% agree with your comment right here, Kimberly. 100%.
Mr. Brooks, my first question to you is, do you have a position on the state's request in their motion for reconsideration? I'm looking for a yes or no answer. I'll unmute and provide that to me. Go
I
ahead.
didn't hear what they said. I just put the headphones on, so I didn't even hear what she said.
Sir, it's a written document that was filed, and you were provided a copy of that yesterday. We took a recess yesterday, so it could be served upon you. If you haven't read it, that's your choice. What I'm asking you is, do you have any position on their request for this court to reconsider the denial of the state's request to prohibit the photography and video recording of victims and witnesses, and specifically their faces, while they testify?
A ruling was already, we already talked about that. You already ruled that the victims and witnesses will be shown. That was already ruled on.
You are correct, but they filed a motion for reconsideration. That's the document that was provided to you yesterday. I'm asking if you have any position on the request that I reconsider my ruling.
Yeah, it was everything's supposed to be public. This is a public trial. I don't understand why there would be even the need to reconsider what you already ruled on at this point, as far as to that particular issue.
I take
It's a public trial. It's a public trial. And essentially watch the trial. And like I said, as far as with the technology that we're in now, if they have to be sworn in by name, that in itself makes them easy to, if somebody wanted to pull them up or find them or find out who was testifying at any given time testimony is given, it'd be pretty easy for them to be found and to be seen. So, I mean, that's just the age we're in anyway, as far as with social media and Google and all these different
Oh, we
things. We
watching.
got all this technology basically at our fingertips. So I don't understand how it needs to be changed at this point when it was already ruled that this is a public trial. There's going to be a lot of things that are going to be shown. Why not keep everything public the way that it's intended to be? And because of the fact that you've already ruled on it, made that on a record.
Do you think by him wanting to keep it public, he thinks, oh yeah, let's keep it public because they're gonna mess this up and I'm gonna have an appeal and everybody's gonna be on my side?
Let's keep it the way it is.
All right, thank you, Mr. Brooks. I appreciate your legal analysis of that and your factual
Your legal analysis of that.
analysis of the prior ruling that this court gave. I thought you did an excellent job making some very good points, many of which I relied upon previously. There is no doubt this case has received great public interest, but this is a case that the state brought charges, and rightly so. I understand it won't be easy, it may be messy, it may even be stressful, but it's important to the integrity of these proceedings, the perception of how things are conducted in this courtroom, that all witnesses, that all victims, with the exception of the one thing I accepted previously, be viewed in its fullness to the public. I maintain the exception for juvenile witnesses. I want to keep this
Barbara said that no, there's no news yet on his appeal. And let me tell you, Miss Barbara Schultz, she's on it, honey.
trial going, and that's what we will do. So the request is denied.
But I did not hear if you, I was kind of overhearing that you addressed the filing that I filed this morning. I didn't hear exactly what was said. I'm just making sure that you know that I'm not trying to interrupt. I just want clarification on what I may have missed.
I'll tell you what I ruled previously. I've reviewed the filing. It's entitled Objection by Affidavit to the state's response in the court's opinion and order and defendant's disclosure statement by affidavit. It's an affidavit. It does not request any relief from the court. I have interpreted what you have filed as an objection to be noted on the record. It has been accepted. It has been filed.
I don't know, Matt. I mean, I was reading what you said. I don't know. Yeah, I mean, they could just draw it out, but gosh, can you imagine if they had done that? That would have been horrible. If they would have drawn it out with delays like they're doing this Sarah Boone case with different problems they're having with him, and because he would have been so difficult to deal with anyway. You might have a point there. So I don't totally disagree with what you're saying.
And that your objection is noted. The court need not take any specific action as it relates to it.
Can I say one thing about that?
Quickly, sir. I need to keep going.
I was filing that paperwork. I would say pursuant to the federal rules of criminal procedure under Rule 12.4 about the disclosure statement.
All right, I'll note that for the record, sir, but it was not in your filing.
So that's a judicial determination, Your Honor?
believe I had one other thing. Oh, I did want to put on the record, and that is when we were testing the audio, I did advise the Sheriff's Department to let Mr. Brooks know, to ask him on my behalf if he wanted to come back into this courtroom. My understanding is he declined.
No, that is not accurate, Your Honor.
Mr. Brooks?
The reason.
Mr. Brooks?
I would just want it.
Hold on, I'm going to mute you for a second unless you stop and listen to me.
I just heard what you said, but I just.
I'm not asking for a response, sir. Mr. Brooks?
It's not.
Okay,
it's not
you're
accurate, Your Honor.
interrupting, hold on. You're interrupting me, sir. I wasn't looking for a response. I will give you the opportunity to come back into this courtroom. You have demonstrated that you can make cogent, coherent, articulate arguments on the record. You just did that. You've been respectful for the time being. I will ask you, sir, do you want to come back into this courtroom? You've been unmuted to answer that question.
Not until I can receive medical treatment for the bruise that I have on my arm and the cut. You just said a while ago on the record that you cannot see blood. That's because I wiped it on my pants, and you can still see the blood in the cut and a big bruise right here on my arm. I was told that.
Can
the
y'all
nurse
see
would
that?
be coming
Should I
in to see me.
wait? Should I put that back in slow motion so we can all look at it? Let's see. Let's take the comment off. Let's go back. Oh, uh, I don't know if I can zoom in, everybody. Hang on. Let's see if we can see the cut and the bruise.
You can still see the blood.
Do you see the blood? Do you see it? Help me find it.
In the cut and a big bruise
Right there, that big old, that's a shadow. That's a shadow, Brooksy. That's a shadow.
right here on my arm. I was told that the nurse would be coming in to see me, at least get the cut cleaned out and get it bandaged, and for somebody to look at this bruise. That was my position on why I was not yet ready to come back into the court, because I felt like this needs to be addressed.
All right, Mr. Brooks, I understand your request. I'm denying the request to take an adjournment. Or I'm sorry, to take a break at this time.
Which my thing was, I
Mr.
wanted
Brooks,
to
you've
get
made
seen
your
by the
record,
nurse.
okay? I don't need you to go further with that. You've made your record. I'm going to mute you for the time being. I want you to be aware, sir, I was advised regarding the cut. The bruise is new information.
Barbara.
I made a determination that you would be seen at the next appropriate break. From my perspective, a small cut and a bruise is not going to hold up the start of bringing the jurors in and advising them of the preliminary jury instructions. If that means the next break we take is for lunch and that's when you are seen, then that's what will happen. So I don't think I've overlooked anything, Attorney Opper, but anything you had on your list?
Yes, it's never a mannequin. Doesn't he have some of the worst tattoos? They're just, ugh. They're ugly.
Nothing else on my list, but we want to give Mr. Brooks one more opportunity to change out of his orange jail uniform, excuse me.
That I would give him an opportunity to do. Mr. Brooks, would you like to go back and change into your suit?
My position has not changed whatsoever, and it will not change, as it is my right to come into court how I would like to. Just like I should be awarded the right to be present for every proceedings in this trial.
All right, I'm muting him again. I note your objection. I will take that as a clear indication you do not want to go back to the jail to change into street.
You guys know that when she got to hit that mute button, there was like this little tingle of just satisfaction every time she got to hit that mute button on him, you know?
Or civilian clothing, that you are exercising your right to dress in the jail attire. Let me actually go back on the record for a second. Mr. Brooks, when the jury comes in, I am going to read through the preliminary jury instructions. Since those have been approved by the court, if you happen to raise your sign, I'll note it for the record, but I'm not going to ask you for any type of argument on that because we've already had that opportunity to do so. It will take me some time to read through the instructions. I don't know if that will take us to the lunch hour or not. The state should be potentially prepared to go through its opening. Mr. Brooks, if we do get to that point where the state is giving its opening and you have an objection, you need to write down the objection in addition to raising your hand, and I will rule on the objections after the closing statement. So you must write down the basis for the objection and what you're objecting to, in addition to holding up your sign. That's the procedure that we will follow. Right now, we're on a short break until the jury comes in.
Keeps going. So cool. All you guys are coming in from all over the world. This is so cool. Scotland, Australia, the UK, France. We got all the nations represented in the house. Did not touch me. Ain't nobody got Matt. Alaska. Oh, I forgot about Alaska, Christine. I forgot you were over there. So that's that. I just wanted to come in and play a short one for you guys today. What song is that playing in the background? I don't know. I use Epidemic Sound, and before that, I would use some free stuff on YouTube. I honestly don't remember. And now I've gotten so spoiled because they automatically put it up for you on YouTube who you're listening to. So they might actually add it at the end of the stream, and you can go into the description and look and see what it is. I know, right, Jordan? It does. It shows how many people outside of the United States were so interested in this. In Little B Town, Waukesha. We he one thing I first was for sure he brought us all together, didn't he? That was if he actually did one good thing ever in his life, it was that we all got to be on here together and meet each other. All right, well, I got another one dropping. I'm working on one for about his mom. And I got a comment the other day that somebody said something about hate speech. And I was like, what? Hate speech? I don't feel like we do any of that on this channel. I mean, we talk about Darrell, but that's it. So I kind of didn't like that. I actually took high offense to it because that's just not what we do. So, with that being said, anything else you guys want to watch while I'm on here? What time is it? Yeah, I got to go here shortly because I got to go take the dogs for a run. You're so welcome, Jamie. Thank you for tuning in. I appreciate all of you guys for coming in. Somebody asked earlier, when is he going to get moved to the big house? I don't know. I think they're waiting for these other trials to be over, aren't they? The ones in Milwaukee? Which, speaking of which, if you go to my channel, just go to the main page, you'll see on there I've got the trial dates for the first days that he's supposed to show up, and they're going to start. And even there's two different ones. I've got all those live streams already set up, so you can go in and click. If you click on each one and click the notification bell inside there, it will send you a pop-up and reminder when we go live for those. Australia wept for the victims. Thank you for giving us the opportunity to meet. Oh, Sue, that's awesome. The recall or the COVID test? Oh, the COVID test. He's in Dodge already. He is in Dodge already? Barbara. Didn't know that. Yes, thank you. I always want to spell it. Psychic, thank you. Please hit the like button on your way out, guys. If you don't mind, it helps me tremendously with the algorithm. Okay, let me see what I can find for you. I'll present one more, okay? Let me see what I got in my grab bag. Do a real quick one. It just takes me a minute to find it because I got so many of them. And we've got the West trial sentencing coming up in July. Oh, yeah, I want to watch part of the police interrogation? That's a long one, though. That's too long for right now because I got to go here in a minute. Hang on. Oh, here's a good one. Let's watch him when he was young and stupid. Oh, I'm sorry. He's still stupid. This is from a documentary he was in. Have you guys all seen this?
I didn't think about, I got this beautiful kid
Look at the
who's
gold teeth.
going without my
Tifa says,
time. I thought I would just be this wonderful father, just be the greatest dad ever. The vision is just like, I'm gonna give him everything that I didn't have. But then it's like reality set in.
and he didn't give him
You
anything,
actually become
even his
the
attention.
drug, not even a human being. Basically, that's how I felt. Like I wasn't a human anymore. I was just something vile, disgusting, despicable. I could go on. I could use a lot of words, but that's what I became.
Thank you, Kimberly.
It's really what I became. What you're doing when you enter this life is basically you're signing a contract. It's very fine line. You're past that now. Now you're druggy. Oh man, if I was 15 again, if I was 15 and had most of the opportunities these kids have now,
Shoot,
I
you
would
wouldn't have
probably
done
be
nothing with them.
doing flips down this thing here.
No, you wouldn't. You'd be sitting on your butt. That was it. Hang on. I'm looking for the COVID one y'all were talking about. Hang on. Let me see if I've got it. I don't know if I have it or not, you guys. Hang on. Got to go through my. I got too many videos of him. There's the one with the shock device. Maybe I didn't redo the COVID one yet. I thought I did. I thought I had redone that one and put it up. My favorite one was when he argues the civil paperwork. That's one of my favorites. I do not see it on here. I guess I have to redo that one, you guys. I'll redo the one where he wants to call in sick because he thinks he's got COVID. I have to redo that for y'all. So if you haven't been watching my channel long, so when I first started on YouTube last year, I put tons of clips up of this trial, and I didn't know that I had to do commentary or I was required to do commentary. They totally demonetized me for like 30 days. So I had to take everything down and kind of if I put it back up, I had to put it back up with commentary. So some of the videos you see of mine are older videos that I'm kind of redoing and just kind of adding, they're either going live with them and talking over them or redoing the videos altogether. So I will work on the one with the COVID. I just watched it so many times. I just felt like I'd already put it together, but not a worry. I'll take care of that one. That would be great for the school of law. I'll put that together for the school of law for y'all. Have you been watching those training manual videos? I certainly hope so because you're going to learn so much. And if you ever get charged or you ever get in trouble, you can always follow Mr. Brooks's, um, what he does, and it'll help you get off. It'll help you get off them charges. Or you might get sentenced to jail for over 1,000 years, but you know what? It's a chance we all got to take. Oh, yeah, Leslie. These are the scariest people because they always believe what they say and they have made themselves believe it even is nonsense. Yeah, you're absolutely right. It's like when a liar lies, they actually believe their lies. I had to write, I will do commentary 1,000 times on the YouTube. Well, no doubt. Good gracious. Oh, hi, Joy. Welcome in and thank you. You're just catching us at the end of this one, so you'll have to go back and watch it from the beginning for us. So I'm going to go walk the dogs, you guys, and I might be able to get another video out later this evening. If not, then I'll do it. There'll be another one that I'll drop tomorrow on this same topic because the Lord knows there are plenty of clips for us all to watch over and over again. 1,000 years guaranteed of bad food and friends, right? Yep, Sue Ashby, you are absolutely right. It's like it's like we put him in a pool full of people, like his people. You know what I mean, Sue? And like they can all come together. It's like a dating site without the site. You know what I mean? I'm so glad you love our videos, Cece. Thank you so much for tuning in. And I might do y'all want me to do a live video of our training manual? That I might have to do a live stream of that one day, maybe. All right. Y'all be good, and I'll see y'all soon, okay? Take care of each other. Stay blessed. Denver Nuggets. Hey, I'm not into the Denver Nuggets right now. You know what I'm watching? I'm watching the NCAA baseball. The Super Regionals. Y'all be sweet. See you soon. Carrie's out.